the contractor does need to have the right to terminate.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, construction attorney Greg Reaume tears down the AIA Form 201, or the General Conditions of the Contract for Construction. The American Institute of Architects Form 201 governs countless large construction projects, as lawyers often pay for the right to use their standard language. But, as Greg points out, blindly incorporating the AIA's language can cause you some real trouble. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I am Mike Whalen. The purpose of this show is to do what it sounds like. We take contracts, we beat them up, we're mean mostly, but occasionally nice. I'm here with a smart friend, Greg Reaume. How are you today, Greg?
I'm doing great. I've had my coffee. And only coffee.
I've had a little extra caffeine today. It is a Monday when we record, which is just, I don't know how Oprah does her show on Mondays. That's what she's just a superhero because of Mondays. Guys, today we are talking about a particular document. Let me share this with you really quick. This is the AIA document A201 2017 General Conditions of the Contract for Construction. The AIA is the American Institute of Architects. This is a standard document. Tell me, Greg, why are we talking about this particular document?
So we're talking about the AIA 201 because that's the general conditions to a bunch of upper level documents that the AIA has. And the AIA is the American Institute of Architects. They publish form contracts. They have for 100 years. They're widely used in the private construction industry. And this is kind of the backbone document of that form family.
Cool. And we'll dig into that. But why you, Greg? Why are we talking to you about this document? Tell me a bit about your background.
So I'm a construction law attorney. I've done a lot of construction transaction work and a lot of construction litigation work. Right now I do primarily litigation. My family are all contractors. My brother builds hotels in LA. My father did the same with residential stuff. My uncle does high-end residential. I worked in a construction company for a while as general counsel, also as director of operations. Then I started my own firm doing construction transactions and construction litigation, joined a firm called McInerney and Dillon based out of the Bay Area, out of San Francisco in California. That's all they've done for 70 years. And I'm actually transitioning now to a firm called Haight Brown Bone Steel. Same thing. It's all going to be construction litigation. We're doing stadiums and hotel projects and big office tower, projects in San Francisco. So very familiar with these contracts, and I have a lot of strong opinions about them. So hopefully I don't offend any of the viewers.
So is this one of those things, just as an aside, where like the whole family, because they're all in one business, they were like, lawyers are the worst, I can't stand lawyers, but now they've got a lawyer in the family and they just all call you all the time? Was that just me?
So no, everybody calls me from my family, but my dad was a lawyer too, and but then just hated law, so went into construction. But yeah, I do get a lot of calls for usually not about construction.
Yeah, I'd rather them call me for that than the family law stuff. That is, you guys are telling me way too much about your lives. Okay, so we're going to get into this document, and we're going to start with sort of a principle. We normally will end coming back to a principle, but let's start with the big principle. If you guys notice on this document, it says the word sample across it really big, which, yes, there's all kinds of copyrighty, tradey, marquee things on there, and, Preston will get mad at me later for using this document. But if we go over here to Law Insider, you'll see essentially the exact same language. We have another document in this filed document. It's a 10Q filing with the SEC from a company called Newskin. And I mean, copy paste, right? It is using the exact same language. So this document that is super protected is used all over the place. Talk to me about that a little bit, Greg, about the sort of standardization of this kind of document, the standard uses, the reuses, and how that, maybe could get somebody in trouble.
Yeah, so these are copyright protected documents. It's part of how the AIA makes money. Typically you would download this from their software, pay $80, I think, for a single use, or you can have like a year-long subscription. They go to great pains to make it hard to cut and paste from any of these. That said, they are widely available on the internet because they're so widely used. So you can easily find copies, and you can download them directly from their site. They have sample copies on their site. So there's absolutely no copyright infringement from using a sample. All of the construction form document families operate similarly. There's about 4 big ones where you pay a fee and then you download their forms to fill them out. So in this case, it's, we haven't paid the fee. I probably have 1,000 of these that I paid for that I could bring up right on my computer. But yeah, you can find them online as well.
Yeah, and if it's filed with the SEC, it's not our fault. Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. Okay, so we're going to go through this thing, and we're moving pretty quick because we got a bunch of complaints. I mean, Greg really is just a complainer about the most esoteric things. This is the thing about being a lawyer. So we get really passionate about things nobody else cares about. So we're going to jump down to Article 2 about the owner, down to 2.2, evidence of the owner's financial arrangements. What's bugging you about this section 2.2?
Okay, so in general, as in quick background, this form document series is made by architects and for architects. They revise it every 10 years. So the last time they revised it was in 2017, and before that in 2007. What you'll notice over the years, the revisions get more and more owner-friendly and architect-friendly. They used to be a collaborative endeavor where they would get the various industry organizations together, get input, and then revise the contracts every 10 years. That pool of commentators has gotten smaller and smaller and smaller. And what you find in the more recent versions is that the contracts go to great pains to protect the owners, the billionaires who need lots of protection, and the architects who aren't a party to the contract. So as you go through this, you'll see the architect has no liability here, the architect has no liability there, and they're like, wow, this guy's really getting out of a lot of stuff, but the architect's not even a signer. So getting to section 2.2, this is evidence of owner's financial arrangements. My quick point on this is keep this in. You do need this in case you are not getting paid, because you need to be able to see what the owner has in order to decide whether or not you need to stop work and had justification to stop work.
Jumping down to 3.7, permits, fees, notices, and compliance with laws. In 4, it talks about concealed or unknown conditions. Tell me what's bugging you about this section.
So this is just kind of another, funny, I just want to illustrate how, if you look at the middle of this paragraph, at least in the 2017 version, it says right about the middle, it says that the architect determines that existing conditions differ materially and cause an increase or decrease in the contractor's cost of work or the time required to do that. It will recommend that an equitable adjustment be made to the contract sum or contract time. The point there is just to show that this is talking about different conditions. If a contractor bids a project that's in a certain state and they get to the project and it's completely different from what they bid, they should have the right to issue a change order or make a difference in the contract sum or amount to get compensated for that difference. What this does, and throughout, is it inserts the architect in between that. So the contractor arrives and says, hey, I have the right for a change. And then they say, whoa, maybe you do, maybe you don't, but let's let the architect decide. And it's kind of like the architect's they're not a party to the contract. Why are we suddenly throwing the architect in here? But you'll see that throughout. I just thought that this was a good illustration of that. You might want to cross that out if you're negotiating these contracts.
Speaking of esoteric and nobody cares, I was going to make a reference to the Matrix and the architect concordantly. We're going to move down to 3.10. Down in 3.10, point 2, we're talking contractors, construction, and submittal schedules. Point 2, what's bugging you about this area? Promptly after being awarded the contract and thereafter as necessary to maintain a current submittal schedule, et cetera. What's bugging you about this area?
Another general point here. This contract talks about how you will submit in a construction project, you're going to submit many things to the architect and the owner for approval. Now, these contracts have very draconian measures for the contractor not finishing on time. The schedule is very strict. There's liquidated damages. There's all kinds of stuff like that. But what you'll notice as you go through is there is no penalty or no incentive for the owner or the architect to turn around their deliverables on time. So if the contractor doesn't do this in 2 days, penalty. If you submit something to the architect like a submittal, how long does the architect have to finish that? Well, it's like a reasonable time. We don't really know. The architect gets just as much time as they want, and if that delays the overall project schedule, who gets punished for that? And here, it's the contractor gets punished for that, even though it was the architect who caused the delay. So if you're drafting this, make sure that you tack on a defined number of days for the architect to complete their process. And if you don't, it's going to be open to a reasonable amount of time, and that could have very negative impacts on the contractor's schedule down the line.
314 talks about cutting and patching. 314.2. What about this one?
That's just a quick one. All I would add to that is sometimes in these contracts, you get the owner having another separate contractor that they put in. If you get a separate contractor coming in there, make sure that you account for them impacting your work, as I would say, not a big point.
Yeah, and I want to pause and ask you a bit about the background on this document. I'm going down to 4.2, where it talks about the architect and the administration of the contract. Step me back for just a second, and you mentioned this a couple times. Tell me about the relationships of the parties to this contract. So you've got AIA, which is an architect-friendly organization, obviously, and then the parties to the contract are the contractor and who, like, you. It seems like you've underlined this idea that the architect's not actually part of this a couple of times.
Yeah.
Tell me where this bias is sort of coming up and how it relates to 4.2.
Yeah, so there's the AIA contract. Family has a bunch of different contract types. They have one between the architect and the owner, and another one between the contractor and the owner, and they're supposed to interplay. When you buy one, it used to be, it's a little bit better now in the 2017 version. If you buy a contract between the owner and the contractor, it used to be that would reference the owner and architect contract, so that you'd also have to buy that, so that they were all interlocking. They've kind of separated them out more, so they are more standalone documents. But typically, the owner hires the contractor, and then separately the owner hires the architect. They each have their own respective contracts and scopes of work. Mm-hmm. And so there's what you can see in here in this section 4 is there's still a lot of crossover. So there's this whole section about the architect. What I would say about this Article 4 is just double check the reality of this with how your projects work. So if you read through this, what it has is everything goes to the architect. The architect gives an okay, and then things move forward. And so but that's not really how, at least in my experience, a lot of private construction projects work. Typically, it's a lot more that the contractor's submitting things to fund control or directly to the owner or the owner's representatives, and then the architect's on the side. And if that's how your construction project works, you should really look at this Article 4 and just remove a lot of the stuff where the architect is inserted, because the architect isn't as relevant as it would appear by according to the contract documents. Mm-hmm.
So might be relevant in the bundle, but in this particular document, think of it separately. Am I getting that right?
Exactly. That's it. That's exactly right. Yeah.
Right. Okay, so jumping down to Article 7, this is always the issue, is changes in the work. Talk to me about this section, how they're dealing with change orders. Do you like the approach that they're using for changes in the work?
No, so you should definitely, folks should definitely be negotiating this hard. And I can tell you that typically, let me give you a general review. In theory, the way that changes work on a construction project is, things are going along, a change needs to happen because, the architect saw the project half completed, went to the owner and says, I don't like that this is elephant ivory. We should really have gold leaf. And the owner says, oh, yes, that's a much better idea. Let's make this gold leaf, And then they go back to the contractor, and the contractor says, well, I bid elephant ivory, it was $5 a pound. Gold leaf is $20 a pound. So I'm going to need a change order to do that. In theory, what should happen is the owner should say, okay, great. Here's a change order. I sign it. I give it to you. That modifies the total price of the contract. Now it's more and you have more time. Go ahead and do the work, right? In practice, what happens is the owner says, I want gold leaf, do it now. And the contractor says, okay, I'll do it. I'm just trying to make you happy and get things done. Are you going to pay me? And the owner says, oh yeah, for sure. I've got millions of dollars. Definitely going to pay you. Turns out at the end of the project, uniformly, the owner decides, I just don't want to pay that much for gold leaf. It looks great, but you're going to have to sue me to get it. Here's my suite of lawyers. Good luck. And so that first way of doing it, the theoretical way is the typical change order process. The second way is what's called a change directive, construction change directive. So you kind of want to be very careful around the construction change directive language. That's in this section 7.3. Just make sure that when you go through it, you assign, if you can cross it all out, great, right? But if not, make sure that you assign a schedule impact towards the turnaround time for that actually and the change order section. In other words, when this process happens, typically what happens is that the contractor will submit an estimated change to the owner and the architect and say, okay, your change for gold leaf is going to cost you an extra $10,000, right? Do you approve that before I begin work? And the owner and the architect are supposed to review that and say yes. Well, the time to review that change never gets accounted for. So you might submit it to them, and then the owner says, oh, I didn't realize it was going to be this much money, starts arguing with the architect. Now a month has gone by, and the contractor has not been able to work on this project because the architect and the owner are still arguing about the change. Well, if you look in here, there's no way to account for the time that's been eaten up by that. That's going into the contractor's schedule. So make sure that you assign a time for that type of negotiation, a time for how long it takes to get a change order done. That's one thing. Another thing that's extremely important is all of these sections say, if you begin work without the owner signing the change order, then you're not going to get paid for it. So one might think that if the owner says, hey, I want to have gold leaf here, not elephant ivory tusk, go do it, and emails that, right? That the owner has made a contract to pay for that. Not the case. Everywhere in here, they go in great pains to say, if the owner doesn't sign it, you're not going to get paid. So in real life on a construction project, what happens is the owner says, go do it, I'm going to pay you, never signs anything. Right. And then there's a big fight at the end. So make sure that what I always try and do is I try and get out that signature requirement. I redline that and say, if you issue a change order, you can send it over, but a written change order is all that we need, not a signed change order. So that's a big difference.
Yeah. How to say I work in casino-related litigation without saying I work in casino-related litigation. Change it from ivory to gold leaf. Jumping down to 8.31, speaking of changes, 8.3 deals with delays and extensions of time. What about 8.3.1 is bugging you there?
So this one, what folks will notice here is that this is a very important clause because this is what gives the contractor the right to extend the project schedule. Critically important if there's liquidated damages. You'll notice at the last sentence, it says the architect determines how much time the contractor needs to finish something. So the architect who doesn't build anything, the contractor says, okay, we need to install this steel truss system. That wasn't accounted for in the plans. It's a change. It's going to take us an extra month. That's what our steel subcontractor is saying. And then this clause throws it to the architect to decide, well, I don't think a month is really necessary. The owner says we need a week. You're going to get a week, right? Shouldn't be like that. You should modify this clause to make any delay and extension in time either up to the contractor or mandatory, but something that takes it out of the hands of the architect and the owner, and it's a little bit more objective.
We've just got a few more points to get through for you guys. We're going to jump down to Article 9, talks about payments and completion. This is a pretty robust section, actually. Unlike others, we're getting into multiple pages. What about this section is bugging you?
It's exactly that, getting into multiple pages. So what you might just think about it, like it's Article 9 here. God, this is like...
Yeah, it's like 5 pages.
5 pages, yeah. All about payment, right? Here's payment, like the work's done, payment money. Why would there be 5 pages about payment?
You're an optimistic lawyer. You're pretty optimistic for an attorney.
Right. I can assure you the contractor did not write 5 pages of things that need to happen before they get paid, right? So this is 5 pages of why you won't get paid if you're a contractor or you shouldn't get paid. So if you're an attorney for the contractor, just take a good look at all of the reasons why the contractor shouldn't get paid. Try and get as many out of them as you can, and just try and make it simple. If you do the work, you get paid.
Section 9, pay me.
Exactly.
Period.
Exactly. Pay me that money.
Jumping down to Article 14, we are getting into the termination or suspension of the contract. I'm assuming with these big projects, here's a place where it should be 5 pages, right? Like it should be really hard to kill these deals. What do you like and not like about 14?
So this is, there's not too much that's bad about this. This comes from personal experience where I've had it, and I can't remember where it is in here. I think it might be right below. But if there are problems on the project, there's a continuing obligation of the contractor to work on the project, regardless of whether or not those claims are resolved. So you might find yourself stuck in a situation where you haven't been paid, nobody agrees on what work's been done or how much payment there should be. And so, the contractor might be like, well, I need to just cut my losses here and leave. I've got other jobs lining up, but you're stuck because the contract says you have to continue to work. So in that case, the contractor does need to have the right to terminate. And so you gotta be careful how this clause interplays with that continuing performance clause, which I'll point out later because I think it's in Article 15. And you have to be careful about Article 14.4.3. That's in the 2017 version, because in a typical contract, typically in contract law, if someone terminates without any reason, then they owe the other party the profit they were going to make. And the reason for that, at least in my mind, is that it's an opportunity cost. This person got into a deal thinking they were going to get a certain amount of profit, and in doing so, they left other deals on the table, right? So if you kind of get the work out of them and then terminate their contract and try not to give them profit, they could have taken other jobs during that time. So the last article in there limits what the contractor can recover if they are terminated for convenience to a set amount of things. I always put in either just eliminate that and do it by the common law, which gives you the right to profit, or add profit back in, or add a good fee in there. So just something to be aware of.
Yeah, and wrapping up down in 15, it gets into claims and disputes. You've got, from what you mentioned, that you got to keep going, getting all the way down to, mediation and arbitration, a lot of ways that these decisions won't be made and will take a long time. What about 15 is bugging you?
So this whole article, just take a long look at this, because it's all about claims and disputes. And, nobody knows how these things work on the construction project site. Between the owner and the contractor and the architect, none of them read this, right? So there's an elaborate claims and disputes scheme set out here. Nobody ever pays attention to it. It basically people just start suing each other. But what's critical is that, so far as I can tell, because it doesn't make a lot of sense, and I've actually brought this up on AIA forums, but haven't been able to get an answer from their attorneys. It seems to me that the model is, let's say there's a claim. So like going back to that change order thing that we talked about a while ago, the owner says, I want gold leaf. And the contractor says, well, how much are you going to pay me? And the owner says, either we'll figure it out later, or I'm going to pay you $2. The contractor says, well, that's not fair. And the owner says, continuing performance, you better just get to work. Here's a change directive. So the contractor has to work. Well, now the remedy for the contractor in that situation is to submit a claim. So then that's what this article is about. So the contractor submits a claim, and it's unclear as to when that claim gets resolved in these documents. if you do a strict interpretation, I guess what's supposed to happen is right then the architect is supposed to pop up and say, I'm going to resolve this, even though the architect was probably part of the original problem anyways, and is definitely going to side with the owner, because they're supposedly the initial decision maker. So you want to first be wary of who the neutral initial decision maker is for the claims process. Second, you want to clarify with the other attorney while you're negotiating this, what actually happens if there's a claim in the middle of the project? Because if you've got, a 20-story high-rise being constructed, you're halfway through, and there's a big blowout about something like gold leaf and steel truss, you're not going to be able to, it's not practical to stop the project to go through this claims process that they outline here and resolve that, And neither is it practical to have this claims process going along the side of the project while it's being constructed and not impact the schedule or not take away from the contractor and the owner's personnel to have a little court trial on the side. So it's just a screwed up, in my opinion, system that they've got here. So just in general, take a look at it and make sure that it makes sense for the pragmatics of the situation. But in particular, take notice of a couple of things. 15.1.3 says notice of claims. Throughout this document, and this gets worse if the owner negotiates the document first, redlines it, and sends it over to you to look at, there'll be a myriad of ways for the contractor to lose the right to make a claim at all. So typically, if in that situation with the gold leaf, what'll happen is the owner will say, get to work. The contractor does. Now, according to this section, if the contractor does not then make a claim within a certain amount of time for the ability to make a claim, really, or for that money, then they've lost that right entirely at the end. And in order to make a claim in the correct way, not only do they have to make it in the right time frame, but they have to notify the owner in just the right way. So if you see on this 15.1.3 notice of claims, this references another section, I believe, or it might be actually the definition does in the first part, 15.1.1, references Article 1 point, and this is probably different between 2007 and 2017 editions of how to give notice. So you have to give notice to be a certified mail for a claim. So it's very important that you strike all of that and you say, look, notice is given by email. That's it. Like everybody knows what's going on. The only reason that you would have these multiple steps in there is just to try and get the contractor to, in the hustle and bustle of work and trying to get things done, to lose the right to the claim, right? So you don't want to have notice by certified mail. You want to have by email, something that's practical. And owners will fight that, and without reason. I had a guy tell me like, I just need to know if there's a claim coming. And I'm like, yeah, well, they email you for that. Well, I need to know by paper. And I'm like, what?
Where's the green stick? How can I know? Reinsert the carrier pigeon clause, dadgummit.
Right, exactly. So make sure, and that I would say is the most important thing of that, is that notice provision. The timing and notice provisions are something that you really need to take a look at.
Yeah, and I, as we wrap this up, I'm always thinking about general principles and how we can take this example and apply it to other situations. This is really reminding me of these sort of bundled documents that you see out in the world for, realtors, like house sales. You see this in vehicle sales, where one entity will create a bundle of documents and then everybody will be like, oh, you've already got forms. Let's jump on that. But it seems like, man, you really got to revisit the priorities and interests of whoever created that thing.
Totally. Absolutely. I mean, there's a heavy hand in who created them, biasing, towards that group. I will say as a shameless plug, although it doesn't benefit me personally, but in 2007, because for so many years, the AIA had been driving changes in favor of the owner and architect against the contractor, a bunch of industry groups broke off of that kind of collaborative contract creation group and formed their own group, and that's called consensus docs. So consensus docs attempts to be a much fairer allocation of risk between those parties. There's not like the architect just randomly inserted in here and protected in all these ways. And it's not unreasonable. The consensus docs contracts are in no way unreasonable towards owners. They're just a fairer way of looking at things. So I would check those out. If folks are looking for something But what you typically find is that owners will want to use these. They'll push, push these on the folks. And one other thing I'll say about techniques for negotiating these things is that the owner will have this contract, they will redline it and then send it over. And you can find articles on the internet that'll say how to make this even more owner friendly. So you get these things that you're fighting uphill just to get it back to the base contract. So it's much better for you to redline it first, send it over, and then you can kind of come back to neutral.
Right.
So.
Yeah, getting back to something that was already probably unfavorable. Well, this is an interesting, it's an interesting example of a broader principle about how these things are created and the fact that we all just sort of use them, right? And we create this culture to the point that you're seeing it on Law Insider, like left and right. We did a search for the language in this document. You could see it in all kinds of filings because people are just sort of copy pasting this language. So an interesting example, Greg, if people want to reach out to you to learn more about what you do and to get your insights on construction litigation, what's the best way for them to reach you?
Good question. I would actually say my phone is the best way. That's and I'll just throw my number out there. I don't know how safe that is worldwide on the internet.
What could go wrong? Sure.
Exactly. I get enough spam calls that it doesn't matter. It's 213-926-1516. And I say that because I'm transitioning firm, so I don't have my new email set up. But also, I'm easy to find on LinkedIn is a common way to connect with me. I post construction law articles on there a lot, so it's a good way to keep updated on content.
Maybe
too.
We'll share the LinkedIn link online and not the phone number. Though, if you guys need any kind of loans, if you've got one of those raising money for medical procedures, or Greg's phone number, Venmo. Hook 'em up.
Exactly.
Greg, we appreciate you. And for those of you watching, we appreciate you hanging out for the Contract Teardown Show. If you want to be a guest on the Contract Teardown Show, email us at community@lawinsider.com. And if you go to lawinsider.com/resources, you'll see the documents. We'll create a robust resource and tip sheet for this conversation. Greg, we appreciate you. Have a nice day, and we'll see you guys next time.
Great. Thank you.